are watching the Attorney Show. Our eminent guest for today is prominent immigration attorney, Ms. Rebecca Chen from Reddy and Newman PC. Hello, ma'am, and welcome to our show.
Thank you for having me.
Absolutely. Call our expert on 1-833-88-28872. The number again is 1-833-88-28872. All right, jumping on to the topic for today. Can a company file PERM and or I-140 if you're not employed there? This is an interesting one because I think we've talked about it in the past briefly, but there's always a confusion of whether some person has to be working at a particular place or has to just have the potential or the potential offer to work at that place, kind of a thing, scenario. Rebecca, tell us about what works, what doesn't work, which scenarios, can they use this as an option? When can they not use this as an option? Please tell us this.
Right. Yeah. So the green card process is technically for a future permanent job offer. So something that a lot of people have a misconception about. They think that only the company that they are working for right now can sponsor their PERM and I-140, whereas in reality, that's not the case. So any company that has a genuine job offer for you, a genuine future job offer, even if you have never worked for the company before, are not working for them now, they can sponsor the PERM on your behalf. You don't even need to be in the U.S. You can be outside the U.S. and the company can start the PERM process, get the PERM approved, file an I-140 for you. You can go through all of that without ever having stepped into the U.S., without ever having worked for the U.S. company. In practice, of course, the more common scenario we see is that companies want to file the PERM. It's a long, lengthy, costly process. And so, of course, in practice, most companies will only want to go through that for the people that are currently employed with them. But technically, that is not required. If you're working in India, for example, for the branch of a U.S. company that wants to bring you over eventually, maybe they've been submitting you in the H1B lottery, but you haven't been selected yet. And that eventually they want to start the green card process for you. They could start the PERM for you while you're abroad, before you come to the U.S. Or if you're in the U.S. working for a different company and you're looking for a company to file your PERM, your current company is not filing it, but there's another company that's willing to, they can definitely start the PERM process for you without you having joined yet. There's nothing wrong with that. I will talk about a couple of issues where it's more likely that the company will want you to join at a certain point. So the PERM process from beginning to end, if you're starting it from scratch, is probably 2 years right now, 18 months at a minimum, closer to 2 years. It's just very long. Every step of the process now has increased in the processing times by a lot. The first stage of the PERM process, which takes about 5 to 6 months, getting the prevailing wage determination, it is absolutely fine for a company to start that for you without you joining the company, not being on their payroll. There's no difference really. And the company can go through the whole PERM process for you without you having joined the company yet. But it is probably, if it's a company that files a lot of PERM applications or I-140s, they will more likely want you to join by the time they file the PERM application, which is probably about 8 to 12 months into the process. The reason for that is that companies are required to prove to USCIS later at the I-140 stage that they have the ability to pay you the wage that's being offered in the green card application. And the easiest way for the company to prove that is by having you on their payroll. So that's why companies, if they are not requiring you to join right away, but they're willing to start the PERM process, but at a certain point about a year in, they tell you that we need you to join, that's going to be why, because from the time the PERM application is filed, the company is required to show ability to pay you the proffered wage, and payroll is the easiest way to do that. The only other ways to show that ability to pay are from the company's federal tax returns, which depending on the company's accountant, from accountant's side, they want to show that the company has as little net income as possible so that they owe less taxes to the government. For immigration purposes, that's not as great because if they have negative net income or a low net income, then they're less able to show ability to pay you the wage unless you're on their payroll. So those are some of the considerations that go into, whether or when you should join a company, if they're willing to file your PERM, but you're not working for them yet.
Got it. And at what exactly is the point in the whole life cycle of this PERM where a person has to be at current employment in your company for them to be eligible for their green cards? Is there a certain point where they really have to be in the company, or can they go through the entire process without ever being hired by you?
Technically, you can go through the entire process and get the green card without ever having worked for
Yeah.
the sponsoring company. It's
Wow.
not as common because
Understood. Yeah.
usually, like we said, the company will want to, in order for them to be willing to go through the time and expense of the process, they will want the employee to be on board at some point in the process. But technically, because it's for future employment, and we've done applications like this sometimes when we've gone through the entire PERM, I-140, even filing the I-485 application, and the I-485 gets approved, and the employee has never worked for the company in the US. So technically it's possible, and as long as that job offer is always there, as long as the petitioning company is always willing to state that they have this job offer and they're keeping this position open for this employee, the I-485 can get approved, the person can get their green card. That's absolutely fine. And we have done it before because the more common situation to where the person has never worked for the company before, we see that more in a situation where the employee is abroad and somehow has a relationship with the US company, like maybe they work for an affiliate abroad and maybe, like I said, the H1B lottery hasn't worked out, or maybe even the employee doesn't have a bachelor's degree and so can't qualify for an H1B. So sometimes companies will use the green card process to basically bring the person over to the US. So the person has never worked for the company in the US before, has never even been in the US before, but the company goes through the PERM and I-140. And then in that situation, since the employee is outside the US, instead of filing the I-485 adjustment of status, the employee would need to go through the final step of the process through the consulate. So going through an interview at the consulate, which can take a long time depending on the consulate. But yeah, that's kind of the more common scenario that we see where someone goes through the entire process and has never worked for the company. But even if you're in the US on H1B working for a different company, if there's another employer that has a job offer for you and is willing to file the PERM for you. And so in the US, in that situation, companies will often use the offer of PERM sponsorship as a way to attract talent, of course. That's a good way for a company to recruit and advertise themselves as employers that are supportive of the immigration process. So even if you haven't joined them yet, they may be willing to go through at least 1 year or so of the PERM process to kind of show in good faith to you that they're willing to file the PERM for you. So in that scenario, it's probably at some point you might need to join the company, but it really depends on your relationship with the company. If they are not requiring you to onboard right away, or even not after the I-140 is approved, that is fine. That is still a valid PERM. It's still a valid I-140 for purposes of the green card process.
Okay, interesting you mentioned that. So technically, a person does not have to be on an H1 or, or they can be on any other kind of visa. For example, they can be a student and, get a company to file for their PERM while they're studying as well.
Yeah, definitely. And that is something that we have been recommending more in recent years as the PERM processing timelines have increased.
Okay.
If you are in F1 status working on OPT with a company, maybe you're trying, there's submitting you in the lottery, but you haven't been selected yet, but you know that eventually you want to apply for a green card and the company is willing to sponsor you, they can start the PERM process while you're in F1 status. That's not a problem. And just to get a head start on it so that you're not
Can
worried
they
about
also
running
do
out of
it
your time.
while they're not on OPT? So say I'm a first year
Yeah.
student who's
Mm-hmm.
coming for their master's. So I can find a
Yeah.
company that's willing to file a perm, you know?
Yeah, technically, if there is a company that's willing to file the perm for you while you're a full-time student, not even on OPT yet, yeah,
Right.
technically they can definitely file the perm on your behalf if you have the qualifications for the job that they're offering.
Okay. And does this also work for people who are on, say, H4 or H4 EADs? Can they
Mhm.
just find someone to file this for them?
Yeah, definitely. So, yeah, that seems to be a misconception also is that you have to be in H-1B status for the perm process to start. You can be in H-4 status, and the company can start your perm process. Even if you don't have an H-4 EAD and you're just in H-4 status, a company can start your perm. If you have the H-4 EAD, definitely the company can start your perm, and do the I-140. Yeah, essentially almost any visa status inside or outside the US, a company can start the perm if they are willing to. It's kind of a matter of your relationship with the company and, how when your negotiation with them on when they start the process, if they want to have you join them eventually.
Okay. And Rebecca, help me understand. On one hand, they're sort of cracking down on people who are not having real projects to work on and stuff like that. On
Mhm.
the other hand, they're allowing people to file for this firm process. So
Yeah.
where does the two collide or, intersect
Mhm.
somewhere?
Yeah, that's a good question. So, yeah, you're right, because on the H-1B side, we talk a lot about having a genuine job offer for the H-1B lottery, for example, and all the duplicate filings where they were essentially fraudulent because there wasn't a genuine job offer. The main
Right.
difference basically is that the green card process is, like we said earlier, for future employment. It's meant to be for the job that's described in the PERM and the I-140 is the job that you would theoretically occupy when you get the green card years from now. And so that's why there doesn't need to be actual employment yet for the green card process. The H-1B is completely different because it's for current employment. The H-1B authorizes someone to work in the U.S. right now. And that's why there are always start and end dates attached to an H-1B. It's valid from like October 2024 through September 2027. There's always a duration attached to an H-1B because it's for current temporary employment. And because of that, there always does need to be a genuine job offer. There needs to be actual work that the company has available for the employee. If it's a consulting situation, that's why we have to ensure that there's a project at an end client site. We need to have the contract work order that shows that there is a scheduled project for this employee. Even at the H-1B lottery registration stage, there needs to be that genuine job offer, actual work involved. So that's the main difference because the H-1B and any other work visa like an L1, anything else, that's for current work. So you do need to show, because it's in the near future, you have to show actual work right now. For the green card process, it's technically not needed because it's in the future.
So, and for those who are, say, not living here and, a company is filing a perm for them, um, uh, can they come at a point where they actually receive their green cards and then come into the country? Is that when they
Mhm.
can technically also come in? Like,
Yeah.
if they can come in
And
before?
that used to kind of be the main, back when a lot of these immigration regulations were written like decades ago, that was kind of meant to be the default way that people immigrated to the US is that they were outside the US and a company had a job offer, would go through the sponsorship process, they would go to a consulate interview and then come in as a green card holder for the first time and start working for the company.
Yeah.
Of course, now there's a lot of reasons why that's not the most common way, part of which is that the green card process is so long now that, no company most companies are not able to wait, that long for someone to come in as a green card holder for the first time. So people come in on H-1B first, where you do have to show a genuine job. And then alongside that, the company files for the green card.
Okay. And is there a scenario where this sort of a setup doesn't work, or are there certain people who fall into certain categories that cannot use this?
And the main requirement is that there's a genuine full-time job offer
Okay.
for the individual from the company, which, doesn't need to mean current employment, but, the company does have to attest in all the PERM paperwork, the I-140 paperwork, that we have this full-time job offer for this person, and we want them to join. Trying to think of others. Yeah, of course, it needs to be, if the company moves locations, for example, after the first PERM is approved, the company would need to do a new PERM application because every PERM is kind of based on the area of employment. So if the area of employment changes at some point, then the company would need to do a new PERM. And if they don't, that wouldn't go through in the long run. But other than that, yeah, the company, as long as they have a genuine job offer, then they can sponsor the PERM for anyone at any stage in the immigration process.
Okay, perfect. Thank you so much for that. And for those who are watching the show, call our expert on 1-833-882-8872. The number again is 1-833-882-8872. All right, on that note, let's take our caller for the day. Okay, caller with number ending in 7732. 7732, we're ready for you now. Hello?
Hi, yeah, I'm ready.
Hi, sir. Thank you for calling us. Please
Hello.
go ahead with your question.
Yeah, thank you. Actually, I'm in L1A in 6th year now. My max out is August 2025. I have a previously H1B from a different consultant, which is I have never used that. And my PERM is also in progress now. So once I get I-140, can I transfer to the previous H1B?
Okay, you said you've never been in H-1B status before?
No, I've never been in H1B status.
Okay, but you have the approval notice. Is the approval notice from your current employer, or it was from a different employer?
That's from a different employer.
Okay. Yeah, it could be difficult because technically in order to be considered counted in the cap, and sorry, did you ever get the H-1B visa stamped in your passport?
Sorry, I didn't get your question. Can you repeat?
Did you ever get the H-1B visa from the consulate in your passport?
No, I have never stamped it. It was a change of status, so I have no.
Oh, okay.
So I have approval, H1B approval with a different consultant.
Okay. Yeah, that may be a bit difficult then, because technically, even if you have an H-1B approval notice with your name on it, USCIS doesn't consider you counted against the cap, the H-1B lottery cap, until you've gotten the H-1B visa stamp in your passport or until you've been in the US in H-1B status for at least 1 day. So that's one obstacle, is that probably you would need to get selected in the lottery again. So you will probably need your current company to submit you in the lottery next year if they haven't already. On top of that, there is also something that you need to be careful about. I think you said you were in your 6th year of L1A status. If you use all 6 years of L1 status, even if you have an I-140 approval by then, and even if you have an H-1B lottery selection by then, you can't really change from L1 to H-1B because USCIS will consider that you've used up all 6 years of your potential H/L time. They kind of aggregate and combine like H and L status. So they will consider that you've maxed out your H-1B 6-year limit, even though you've never been in H-1B status, just because you've used up all 6 all your L1 time for 6 years. So yeah, you'll probably need to discuss with your company to have some kind of plan in place for what to do. My recommendation would probably be to, in order to avoid maxing out those 6 years, if there's a way that you can depart the U.S. before the end of the 6th year, or travel in and out of the country so that you have enough time outside the U.S. to recapture, so that you never use up all 6 years. And then on top of that, have the company file for you in the H1B lottery next year. And if you're selected, and if your I-140 is approved by then they can do the L1 to H1 transfer. The only other alternative is for you to spend 1 year outside the U.S. If you do end up using more than 6 years on L1A status, then the only way to reset the clock would be to be outside the U.S. for 1 full year. And then you still need to have a lottery selection, and then they can file for you in H1B.
Okay, so this old H1B, I can never use that.
I don't think so. It sounds like you aren't counted in the cap based on not having the visa stamp and not actually using or working for that company yet in H1B.
Okay. Either I should go for F1 or go to other countries. That's only F1 is possible, right? I can.
Yeah, so either moving outside the U.S. for long enough for the lottery selection, or if you have another visa status in the U.S. that you're eligible to change to, like F1, you could do that. But the main thing about F1 is that we don't recommend doing F1 CPT as like an alternative to work authorization. That can end up complicating your situation more, in our opinion, than so if you do move to F1, we recommend it be with a school that doesn't issue day 1 CPT.
Okay.
Got it?
Okay, yeah.
All right.
Yeah, thanks for the clarification.
Thank you so much for calling. Yeah. Rebecca, in the past, we've sort of discussed about, being careful about, filing PERM on one hand, and what kind of a visa you're coming on in terms of expressing your intent of coming, right? So will it cause a problem if someone's PERM application is underway and they're trying to come here as a student? Because then...
Probably not.
Okay.
Yeah. So that is a good question, because definitely having the green card in process is kind of contrary to the temporary intent that you're supposed to have for a lot of visa categories like F1, TN, of course, B1 or B2, E3. So not L1, H and L are kind of the only exceptions. But actually, if you just have the PERM process underway so far for yourself, so far USCIS and CBP are not considering having a pending PERM as declaration of your intent to stay permanently in the U.S. The point where you have to kind of be careful is when the I-140 is filed. So once the I-140 is filed, that's where entering the U.S. on an F1 visa or other temporary intent visa can be trickier. But during the PERM process, because that process is with the Department of Labor, and technically it's kind of considered more of an employer-driven process. Even though your name is on the PERM application, the PERM process is really more employer-focused. The government is looking at the employer, checking if they have, done the requirements of looking for a U.S. employee to fill the role, that kind of thing. So if you have a pending PERM, there's no problem. You can go in and out of the U.S. It's just when the I-140 is filed, that's when you need to start timing your travel very carefully.
Okay. Got it. And Rebecca, also for those people, if their current employer is not filing their PERM, or if they're unable to find a company that's willing to file a PERM and or I-140 for them, Are there any options for any other options for them, like a self-petition option available to them? And if so, like, what is the best way to approach it?
Yeah, so if your current employer is not sponsoring the PERM and you're unable to find another company to sponsor the PERM, or maybe there is a company that's willing to sponsor your PERM, but you're too close to the 6-year limit. Maybe it's already your 5th year, and you know that the PERM won't be complete before your 6-year H1B limit.
Right.
Something that we have been looking at more recently is these self-petition options, like the NIW, which is the National Interest Waiver. That's in the EB2 category. And then the
Okay.
EB1A, which is also an I-140 petition for individuals with extraordinary ability. So the advantage of these two applications are that you don't need a company to sponsor you. You can self-petition. Also, the main advantage is that both of these I-140 applications don't require you to have a certified PERM. So the PERM is the thing that's taking the longest, like 2 years. For the National Interest Waiver and the EB1A, you just, once the application is ready, you just file the I-140 directly. You don't wait for anything from the Department of Labor. You just file the application, and your priority date, it's considered the date on the I-140 receipt notice. These two applications are, of course, you have to qualify for these categories. And, it's always best to kind of consult with an attorney to review your CV to make sure you meet one of these qualifications. But if you do, or even if you have, a potential argument to meet one of them and can gather the evidence, then once you file, that establishes your party date. And if you file it early enough before your 5th year, just the filing of the application alone can get you an additional 1-year extension of your H1B. So even if you don't have the strongest NIW case, for example, but there's maybe a 60% chance of success. If you know that there's no PERM that will be finished on time, the NIW is probably your best bet, because if you file it before your 5th year, just the filing of the application, the I-140 receipt notice, is enough to get you an H1B extension for 1 year. And then if your company, for example, in the background is processing your PERM, then they can complete the process by the end of that extended 1 year, and you can get an I-140 to extend for an additional 3 years. So even, being strategic about the timing of filing the application, and even if you don't have the strongest case, if you file it kind of strategically, it can still benefit you as far as, giving you enough time to let a PERM process finish out if that is going on.
Okay. All right. Thank you so much for that, Rebecca. And, thank you so much for joining us today. I know it's Mother's Day, but thank you so much for taking out the time to be with us today and with our viewers as well. We really appreciate you being on the show for us today.
You're welcome. And happy Mother's Day to all the mothers out there. You're having a good day.
And to those who are watching, we will be back same time, same place next week. This is Nitya Baya from TV9 signing off. Thank you.